Welcome, everyone. This is Wednesday, April 17th, 2019, the Brilliance in Commerce House of Freedom Trust webinar with Randall Hildner. My name is Tonson, and thank you for joining us. We really appreciate your presence, and we have been enjoying a monthly gathering in fellowship with those who are already operating natural law trusts and those who are contemplating doing so soon and wish to master the basics. So we're going to continue today with our series, and we have many things developing that are all positive. Freedom from income tax, freedom from debts, freedom from the enslaving wheels of the cabal's global machine, and that freedom is being directed towards a better world. So we want to thank all of you for being the shining bright lights that you are in helping all of this happen. Brilliance in Commerce is a project of La Verite, which means the truth in French. House of Freedom International Natural Law Trust is the brainchild of our good friend Randall, who is going to be on in a few minutes. Liberty Debt Elimination System is for Americans to delete the phony, bogus credit card debt and student loan debt that was created out of thin air and never existed in the first place. We still have, to this day, knock on wood, a 100% success rate there for everyone who has followed the instructions, including the very few who had to take it to court. And we have many other wealth building and credit-related affiliations. We are members of the International Organization of Commerce. You can see here the charter. If you see the visuals, those who are listening by telephone, it's the worldwide charter for fair international commerce, of which Brilliance in Commerce is an honorary signatory. Today being April 17th, 2019, our next scheduled trust webinar is May 15th, 2019. So look forward to that. Put it on your calendar. We'll send out another newsletter with the connection details for that. To play back past webinars, go to brilliance-videos.com. And for those who do not have any way to connect with us on the web, we prefer that you go through the affiliate who introduced you. And if you do not have one, you can go to the generic site at house-of-freedom-trust.com. For those of you who need a phone number for any reason, our company phone number is 360-200-7521. And for those who heard about this from a friend and are not already subscribers to the newsletter, we send out a few newsletters each month, and we look forward to adding you as a subscriber. You just go to the House of Freedom Trust with dashes between each of the words.com website and click on newsletter sign up. Some comments in the chat say the sound isn't working. Others say, yes, it is. The sound is working. So hope everyone is hearing just fine. I guess if those who are not hearing wouldn't hear this comment, but those of you who are watching the chat, kindly just help anyone who isn't getting sound to look for the right audio place to click. My name is Tonson Fairmont. I'm the founder. I'm a member of the board of advisors of Monaco Management Group, and I've been a speaker on many radio shows and offshore investment seminars, and author of Sovereignty Consciousness and Cosmic Renaissance. We call the trust international because it is beyond the jurisdiction of any particular state or country. In the beginning of the trust, those of you who have one will see that we cite the common law of whatever location you happen to be in, unless you prefer the Uniform Commercial Code or you prefer to state some other kind of way of deriving authority for any limited litigation that could potentially ever happen. What's interesting is that in 3 decades of using these none of us have had any litigation around these trusts. That none of our clients that we know of have had the trust subjected to a court. But we do state the jurisdiction as being common law, and natural law is the better term, which we prefer because it refers to that which derives from the essence of the universe. Common law is man's best attempt to emulate that. It has been a best kept secret of the super rich. We know that the Kennedys have used it, the Rockefellers, the Rothschilds, many of the world's wealthiest families. They have not passed it on to the law schools that teach attorneys. And so most attorneys are in the dark about it. They're afraid of it. They'll steer people away from it. They're ignorant. They are not informed. They're brainwashed, and they think the statutory entities are better when they're not. They're quite inferior. They have many more regulations and fees and red tape and bureaucracy to comply with, and long lists of regulations that are always changing, and they're subject to the jurisdiction of Congresses and parliaments. They're not reliable, and they have many, many clauses in them that are in favor of the vested interests, whereas the natural law trust is based on the tradition that the super rich themselves have used. And that allows people to utilize the universal law as one's basis to operate. As derived in common law, it comes under the Uniform Commercial Code, which is basically the set of rules all over the world. Don't steal, don't lie, don't cheat, keep your agreements, and you can do anything you want as long as you don't violate the freedoms and rights of others. Randall Hillner is the director of our trust department. Brilliance in Commerce and founder of House of Freedom Trusts, White Light Unlimited, trustee of One People's Public Trust, and the creator of the Natural Law Trust. And I must say that for those of you who are new, please understand that this knowledge is the creme de la creme. There are thousands of universities and academies that teach asset protection. Most of it is deep in the statutory complex, which is full of fees and risks and backdoors and all kinds of changing regulations that require expensive professionals whom you would then have to trust because they understand it. The legalese is way beyond the education of the average person. These trusts, on the other hand, are much, much, much stronger. They have way, way, way more benefits because, in the first place, they're in plain English. They're based on high school English that anyone on the common street can understand, and do not utilize the complex statutory legalese because it's unnecessary. And so hundreds of pages of trust legalese have been distilled down to about 30 pages. It's powerful, it's bulletproof, it's straight to the point, but it also is absent of anti-government language. So Randall in his genius has created a trust that is polite, that's courteous, but is very, very strong. And don't be fooled by its politeness because it is impenetrable and bulletproof in the same way that the so-called statutory trusts are. Today's topic has the interesting title, The Magical Mystery Tour of the Three Hats. Right now, I'm going to turn it over to you, Randall, and let you please illuminate us with your topics of today.
Well, good afternoon, everyone, and thank you very much for showing up. And
it's a cute hat you've got there.
Well, we got three hats to go through today, and we'll get along as we go along.
I've heard of white hats. You're a pink hat.
Oh, I'm bi. I can go three ways. So, magical mystery tour of three hats. So, I actually gave this yesterday, and it was the first time I'd ever really rehearsed this my talk that I usually do. Usually I ad-lib it totally, but I had a client that needed to know what I had to put on and how to use it. So I said, oh, this is perfect. This is my training for the afternoon. So we started there, and we'll go from there. Now, you only see the green screen in front of me or in back of me. There it is. So I was trying to do this outside today, but I couldn't. It was really windy and pretty hot, so I'll just leave that to another day. So we're going to start, I guess, with, first of all, I want to acknowledge you for showing up, because in the fact that you have a trust and the fact that you want to have a trust, you're looking at something that is a really potent tool to protect your assets. And this is whether it's potential of foreign currency through the RV exchange, or if it's through everyday business that you're conducting, which is totally doable and enhanced by what we do. So I know a lot of you are just looking at the fact that you're waiting for the RV and that's what you're going to use it for. But in the meantime, I have a number of clients, we have a number of clients that are using it in their everyday business, which is totally fine. And so it works a lot of ways, because the most important is this is a contract. And I say 3 hats. This is a contract because there's typically at least 3 people involved. You have the grantor for one hat, you have the trustees have another hat, and then you have the beneficiaries that really have that third hat. And that can each, one of those hats can have multiple participants. It could be a couple, and they're the grantors, and they create this trust, and they have 2 trustees or maybe 3 trustees, and then they have multiple beneficiaries. So that's how we're going to go about explaining all that. So do we have a slide for the first hat? Yes. Now, I just touched upon this a minute ago, but basically, the grantor or grantors is the person that's going to take an asset and put it into a trust. They're going to assign it to the trust so that it's no longer in their name. And what that does is that it takes it from your pocket and puts it into the pocket of the trust, where it is protected by the trustees and the verbiage and the contract. We talk about common law, statutory law, but I'm going to get even more down, is that common law is based on contract law, and contract law has been forever. 2 people shake hands. Some cultures, they cut their fingers and have blood brother. It doesn't matter what it is. The fact is that they are agreeing to have someone else look after their family, assets or whatever. And so that grantor can be single or plural. And that typically the grantor will take an asset and put it into the trust, and then they want it into the trust because they either want it out of their pocket and yet have the benefit of it, or they want it out of their pocket and they want it for the beneficiaries, who may be family or anybody that you want. And we'll get into the different projects later on, etc. But the idea is to have help with your assets. And by taking it out of your pocket, it also means that the government can't reach into your pocket and find anything there. So the most primary thing just off for elderly people is the fact that there's no threat of probate. Because if you have your assets in your own pocket and you leave without, even if you have a will, it will go through probate and they'll attach any of those assets to your estate. And that can add up. And the government and the lawyers will feast on the residue of those assets. And so we want to eliminate that first and foremost. So government's out, the lawyers are out. And I would say that there are some really good attorneys out there that really fight for their clients. So yes, once they step before the bar, their first alliance is to the court. But there are really good attorneys out there that will fight for the client. They do exist. It's just hard to get them. So there's your grantorship. And basically you're going to create the trust and go from there. Now, you can have a nominee grantor, and we do have that service. We have a beautiful woman who's mentoring with me, and she's very excited. Or you can have your own nominee grantor. The nominee grantor is the one that has their name on the first page, and then they sign the indenture agreement. And so they agree, this is what they want to see in the vision. The vision is to have my assets be played out in this way upon my demise, or when I take off for another planet. So this is it, called a nominee grantor. And that grantor, at some point within 2 or 3 pages of signing the trustee or assigning the indenture, they also relinquish all control of the trust. In other words, in order for this to be a non-grant, they call it a non-grantor trust. It's a term where you are the grantor, but you give up all control as the grantor. Now, we're just talking about the grantor hat. We're not talking about another one. So the grantor in that hat as grantor gives up all control, relinquishes all control into the hands of the trustee. We'll get to the trustees later, but basically he's going to choose, or he has chosen, people that surround him and he feels confident with, that they're professional enough or they're friendly enough that they will make sure that they take care of the assets in this trust for the beneficiaries. And we'll talk about the beneficiaries later, but basically there it is. You have the grantor who either creates the trust themselves, or they have a nominee grantor that steps in and signs the indenture, and then it goes from there. Now, so this is what the grantor can do, as well as basically creating the trust. Grantor can be the grantor and the trustee. That's it's a little slippery slide if you don't get it, but basically they can be the grantor and they can be one of the trustees. They are not a beneficiary. So I have many clients that come and they want to create a trust. They want their assets to go into trust, and they want to be either one trustee, or they want to have a trustee service, and they want their family or their projects. A lot of us around the RV are talking about having the results of our foreign currency exchange go to our projects that we want to see fulfilled, or we visualize, if not in our lifetime, that at least carries forward. And if the RV indeed does what it says it's going to do, then there's going to be significantly powerful new wealth in the hands of a different kind of consciousness. Tanzen talks about the renaissance of a new consciousness, a new paradigm where people want to serve the planet and serve other people around them, and really take care of the planet and the people that surround them and make life worth living. It's a key role, so it's something to really think about. Now, if you're not the sole grantor and you're not the sole trustee, then you can also be a beneficiary. So I have some people, for the sake of this, we'll say there is a couple and they have children and grandchildren. And so during their lifetime, they want to create a trust, and they want to be the grantor. One of them wants to be the trustee, and then they want to have some beneficial interest, and they want the rest to go either to their family, and this can be broken up. It's not by the number. In other words, people get confused sometimes because they say that, well, I don't know how much to do because we don't know what's going to happen at the exchange. And I say, don't worry about the number. All you have to do is write a percentage. So you want 20% to you and your family, and you want 80% to go to the projects that you may also have lined up. Or you may want 80% to go to your family outside, spread it around. It's okay to keep the money, the new estate, the new power of this new estate in the hands of your family. As Tanzen mentioned earlier, Kennedys, Rockefellers, Rothschilds, etc. And way back in the early days, the wealthy bankers in Europe said, I don't care who's in power in government, just get me the control of the money source and I will rule the world. And that's all it is. The bankers, as we see more and more and more, are the people that really control the purse strings of any government and all the chaos that does exist on the planet right now. So we want to have the ability to have that same source of power within yourself and within your own state. So that's the role of grantor, and we can come back because it's going to intermingle with the next hat. So we could go to that next hat. Let me change hats. Okay, so here we have what is a trustee and what do they do. Okay, one is trustee but not be a beneficiary. So you could be the grantor and the sole trustee as long as you're not one of the beneficiaries. So I have a couple of clients in particular that put this trust together. They want to take their assets from their own pocket and they want it to go to the family, and it may be divided in any percentage wise. So it can go from immediate family spread out to grandchildren, etc. And by the time it goes out too far, and we'll talk about it in other lines, but you're going to start to have as you get out there, you're going to say, well, we need to take these assets, and rather than having it all in one trust, we're going to break it up, and we're going to, let's see, I've got 4 children and multiple grandchildren. So how about we take this estate and we create 4 trusts, 1 for each child, and they'll process it for so long, and then they may say if they have all 4 children, that's 16. So all of a sudden they may themselves want to create 4 new trusts from that. And that's how you keep on establishing the change in the beneficial interest, but you keep the estate intact the way your original vision is. It just keeps going and going and going, as we see in the Rockefellers and the Kennedys and the Rothschild. The Medici family in Italy, really early on. It's been for use forever. And a trust, by definition, is basically a contract. We call it contract law or common law. It's common law because Britain really defined the role of that whole process. So they established common law in Britain early on because the kings were ruling, and the nobles said, wait, we're tired of this. We're tired of giving you all our profit, and we want to keep it ourselves for our family and on our estate. That's what they did. And they went before the king and said, we're going to create this contract. I think it was, I forget what the name of it was, but basically said, if you don't sign this, we're going to cut your head off. And they said, king said, I think it's an excellent idea. Let's do that. So basically, they created a common law, and out of that came contractual law. And that does exist everywhere. The ability to contract is almost universal. What happens, though, is that, like in France, the rule is not common law, but Napoleonic law. So we have to, working with French clients, we have to change it a little bit and tweak the contract so that it fits with the paradigm of that particular process. Same with, I have a client down in Brazil and South America, and so, and even the Portuguese have a different law in South America than they do in Portugal. So it's really, it's a well-versed thing, but it has to be written in a particular way so that we can serve each client for their best needs. Okay, so two trustees can be trustees. Okay, so here again, let's say you're the grantor and you want to be trustee, and if you want to be a beneficiary or have that ability, then you need a co-trustee that is not related to you. Too many people want to have their brother be the co-trustee, and that can't really happen. You can't have a co-trustee that's related by blood, marriage, or adoption. So we have to have that separation. Otherwise, you have what's called a revocable trust. It means basically you haven't really given up anything. You've just allowed this paperwork that is there, and all it does is eliminate probate. And so that's a big step, actually, because when you think about it, probate will take a third right off the top before they even discuss it. And they'll often let it sit on the desk of the attorneys for half a year before they deal with it. I remember there was a movie, or there's a joke. He said, hey, son, what did you do with this estate plan? And he said, well, I filed it. And he goes, oh, no, man, you just took out a significant portion of our income for the next 6 months. You're supposed to let this ride. And so the son was duly chastised and learned how to be a not so clean lawyer. But it does eliminate probate, and it eliminates any kind of estate taxes. I had one client today that was looking at it, and he said, well, what's going to happen? And I said, well, what happens is that, he said, well, what should I put this in my will? And I said, no, if you assign your asset to the trust, then you won't have anything to have in your will. Your will be just the things that are left that presumably don't have any great deal of value, but that you want them to be parceled out to whoever is left on that list. And
Randall, sorry, I've been meaning to ask you. Your face is dropping off the bottom of the screen, so could you move your camera down or your face up? Yeah, there you go. That's better. Thank you.
There
Sorry.
it is.
Go ahead.
Okay, sorry. Well, you get older, it's harder to keep your head up. You know, just, all right. Speaking of that, okay, so what are we doing? One trustee success. Oh, all right. So now a lot of people, they don't want to necessarily have two trustees right away. So I say it's okay to have a successor trustee. But um, on the paperwork, in the contract, you will be the sole trustee. But when you go to the bank to work the account, the banker will say, we don't want it this way because there needs to be somebody that can step in and take this trust and run with it accordingly to your vision. And so we need at least the name of a successor trustee in case something does happen to you. And we don't want to turn it over to the court. We want this to progress along without a delay. And so the successor trustee, even though they don't really have any power in the beginning aspects of the trust, they're in the reserve. It's like sitting on the bench. You know, you're ready to play and you're ready to go, but you really don't have anything to do until you're called upon. But in the meantime, you have an idea of what's going on. I have some clients that say, well, do I have to let them know? And it's advisable to let, or no, the classic question is, oh, is the trustee going to know all the affairs of this trust? And I say, well, yes, he has to. He's the trustee. He has legal, fiduciary responsibility to make sure that the assets that you have put into the trust are safe. So, sorry, I'm really not used to wearing a hat. So they really need to be well versed in what it is that you want to do. And that's why Tons and I have found this beautiful woman who is learning how to have a trustee service. And she has a nominee grantor service and she has a trustee service. And she's going to offer to you or any of our clients the ability to be available for hire, and you work the terms out with her, but basically she's very reasonable. And it doesn't matter where you are because through the use of technology, we have the DocuSign. So you send a minute to her and she DocuSigns the paperwork and you're ready to go. So there it is. One trustee, two trustees. You can have three trustees. Have a group I'm working with. They want to have. They're doing a big worldwide project, and they want to have. They have five people that are going to lead that process, and so we're thinking about how to set it up so that all five of them would be trustees. So it'd be a board of trustees of five, and it would go from there. And the beneficiaries can be themselves and or the projects that they want to manifest all throughout the world. Very big project. I'm very happy to be involved with it. Okay, how about the third hat? Okay, so the beneficiary is there to receive the benefit of all of these assets. Now, again, we're going back to whether the beneficiary is the grantor or the family or the projects of the grantor. And their whole role is to just receive, and they don't really have any vested interest in the trust. They really can't participate in one sense, but they have the ability to ask for a report on a periodic basis from the trustees. And if the family and the trustees are reasonable, then they will keep the beneficiaries abreast of what's happening. And depending on the estate, the largeness or the cash flow of the estate, the beneficiaries may be paid or can be paid on a monthly, quarterly, or yearly basis. It's totally up to the grantor and the beneficiaries on how they're going to have this whole parlay, so to speak. So now the only thing, the good thing about it is we have two things that I think are important. One is they can hold the trustees accountable if there is any kind of fiduciary irresponsibility. If the trustees are trying to slide something out of that asset base for their own use, or they're not paying attention and they're trying to abuse their position, then they can be fired. There is a protector clause in our trust where the grantor can appoint a protector, and that protector can step in and say, Mr. Trustee, you're not doing your job. You've got 30 days either to make amends or you're gone. And on the other hand, we have a clause called the spendthrift clause, and part of that is that the beneficiary is a little wayward, and he goes out and he spends more than he really gets on a per ticket checking. If he gets paid monthly and he spends more than that, then his debt that he accrues from that spending can't be attached to the trust. It can only be attached to his personal bank account. And the other benefit of that is that he can't go to the trustees and overly complain that he's not getting what he feels he deserves. In other words, the trustees may have a plan in place to build the asset base of the trust, and so that rather than that person getting a bigger chunk at the time, the trust keeps it in hand and builds the asset base and the buying or the payout potential of that whole asset base. So you go from one house to 3 houses to 5 and 10, whereas if you go one house and you pay the beneficiary more and you can't afford the second house, then it doesn't grow the asset base in the trust for future beneficiaries. And so if the beneficiary complains too much, then the trustees can say, sorry, Mr. Beneficiary, but we're cutting way back. And if you complain too hard, if you really get on us, then we're going to take your benefit away completely, and we're going to give it to the other participants in the estate, the other beneficiaries. And so it kind of works together to keep the trustees in hand, and it works to also keep the beneficiaries in hand so that the trust asset base continues to grow, can be given out. The more it grows, the more it can be given out, and it keeps the trustees in line, because any fiduciary irresponsibility, then the trustees can be gone too. They can be fired. So that's the primary role of all 3 hats. And I think I'm ready for some questions, if that's the gist of all of our thing. Okay, ready whenever anybody else is.
Okay, everyone, you can press *9 on your phone to raise your hand, or on the video, you can click the raise hand icon. In the meantime, we have some accumulating in the chat. And so we'll start with First, I'd like to thank E Pluribus Unum for a very nice comment. He says, the subject of natural trust is one of the most misunderstood. Natural trusts have been kept away from the education to attorneys in estate and financial planners for many years. For one to really understand how real trusts function, one must understand the full concept of privacy, secrecy, controlship, dominionship, personal and public protection, but most of all, the nature of the trust. The right trust is like the father that looks after the family and protects the wealth of the family, the authority that keeps you out of most of your troubles, the big brother that guides you in all your endeavors. I believe your trusts are not something that was copied out of the internet, something that will collapse after you've poured assets or big wealth into it, and some government taxing authority or lawsuit will cause it to collapse. I believe your trust has met the test of time, and the money mechanics that is encoded within the trust is designed to help us achieve great tasks after we have learned. So I wanted to thank you for that.
Yes, I thank you for that.
And then there's a question from the same man or woman. Is there any board in the trust like exchanger, trustor, trustee, beneficiaries?
Say that again, please.
Is there a board? He's basically asking, is there a board?
Well, yeah, the board of trustees, whether it's one or two or five, it's considered, the trustees would be considered the board of trustees. And that's the general language we use, because then it covers however many trustees we decide to put in the contract.
And it says, is the agreement between the trustor and trustee irrevocable?
Yes, that's what makes it hold up, because the grantor or trustor cannot take the assets back away or out of the trust to put them in his own pocket again.
And he says, is the agreement between trustee and beneficiaries revocable?
Yes, for sure. Like we just talked about, beneficiaries can keep the trustees on liable. In other words, they can make sure that there's no fraudulent behavior, but the trustees can also come down hard on the beneficiary if he's making complaints that go beyond his what he deserves to have.
Do you recommend to open a non-interest account?
That would be on a bank. I don't. If you're going to have a checking account, I'm speaking now of the U.S. If you're going to have a checking account, it's going to be an interest. I don't know what it's called. It's just called a checking account for the trust. It may, I know what it is. If you have so much in there, in each bank would be different. My bank works with, if it's more than $5,000 left in there per month, then they give you a slight interest. But the really only interest-bearing account would be the savings account. So basically, a checking account is a non-interest-bearing account.
Yeah, the people talking about recommending not having it is just to avoid reporting, but that's really
Minor.
not a very important issue.
No, because we know that we can address that issue if it ever comes up.
Right. David asks, if you could spend a minute about the trust claiming limited liability in the contract.
Well, if the trust enters into a contract for whatever reason or however, and there's a breach in that contract by the trust or whoever they use personally, or if they subcontract for a particular job or whatever, then yes, the trust is liable for whatever occurs out of that breach. uh, if they're not liable, they have the trust has to defend its position if there's a question of liability. In other words, if something happens, if um, the trust owns an asset and it creates an injury, then it has to take care of it.
And are the trustees personally liable for the liabilities of the trust?
No, they're only liable if they commit the breach of trust.
Right.
But they're not personally held liable for something that happens outside their normal working. So we have the trust has real estate, and something happens on that particular real estate property. If the trustees have not had the proper insurance or taken care of the property, then they could potentially be held liable, but typically it's just the trust itself. So if the trust is going to have a piece of property and it is going to be, say, a rental property, then I would tell the trustees that they need to make sure that there's adequate insurance on the property so that anything like that happens, it can be covered.
And then Tony asks, can you address how to set up company in the trust so that the owner of the company receives money from the trust?
Well, the way I work it is if somebody wants to create a company or an LLC, that they do that outside the trust and they have the trust be a member or a member of the LLC or a shareholder of a corporation. So then I call it a storefront and a back store. So the storefront is the one that takes the action, and the back store has the supplies and the needs for that action out in the front part. Does that make sense?
Yep.
Okay.
Abra, you're familiar with Abra? She said, haven't we covered this material already a few times? Will we be getting into more advanced topics of running the trust and how to create trust documents?
Well, you can send me a question yourself. Since you're a client of mine, you can say, I would put it back on you. What is it that you would like me to talk about? And I would be more than happy to present a topic like that on a webinar. And oftentimes, we can cover that in a longish email. But if it's really important, Abra, then it certainly could be a topic that we could have either on part or a whole webinar on. I would love it if people would say, hey, I want to hear about this. I want to know how to do this. I want to know how to do this. And we can make it happen.
Yeah, everyone, if you haven't seen it already, you've noticed that Randall enjoys questions. He wants to know what's on your mind, what interests you. And Richard says, what legal or government challenges has your trust been exposed to?
None that I know of. There's been no warrant on my front door.
And you're in touch with most of the clients out there, so you would hear normally, I would think.
Well, the first thing they're going to do is say, Randall, what's happening here?
Right.
Oh, I'm the first phone call. No, not the lawyer. No, to Randall. So, yeah, it's absolutely. That's what I'm here for.
She said that a classic strategy of war is to prevent the birth of an enemy.
Yeah, exactly. And it's my job. It's like helping you get through the maze of what you think is really confusing. And, it's obvious that for me, I can handle most any question, and all of you that are just beginning, it does take a time. And so, like, I'll have a client that'll ask the same question over and over, and I'll say, look, have you really read the manual? And have you really actually read the trust indenture word by word and underlined it and said, oh, I don't understand this. Can you explain this? I say, well, where is it? What page? And what is it saying? And I'll explain it to you. And I find a lot of clients don't take the time. So I beg you to read the indenture, read the trust manual until you really understand it. And you have to remember, I've been doing this for a long time. So, and I had really good mentors along the way, and they would throw the book at me, say, you should know this and get it together. And if I didn't have the green screen right behind me, you'd see this law library that I have. And it's very stimulating, and it deals mostly with, and I think this is why we've been able to move past most of the obstacles, is when I have a new book and I read the cites and quotations that have come from the court and decisions that they've made, I can say, oh, I see how this substantiates this. This is how this was beaten down, and this is how to proceed around it. And that gives me the ability to work with the client and say, come on, have you done this? We've done this. Have you talked with your trustees, etc.? We can work it all out. So please send me your topics that you want to hear about.
And Richard also asked, how old is your oldest trust?
Mine in particular? I started this in 78 or 79. No. Let's see, my son, 75, somewhere around 75, 78. That's when I seriously started looking into it. So mid 70s, right after Vietnam, came back from the war and started this war.
So that's about what, 45 years, I guess.
Yeah, it's been a while. I've been around. You can tell by my face. It's not an easy face to look at sometimes. It ain't pretty, but
the typical term is 21 years plus lives in being.
Yeah, exactly. How many lives are here in this face? All right. Who else? Come on. Cheer up. It's a beautiful day.
And Richard says, well, does your trust structure include a protector?
Yes. It's right there in the middle. There's the whole middle second section. The first section is the trust indenture, and we have all the signatures that have to be done, the appointments of trustees, appointment in there is the appointment for a protector. There's the appointment or the ability to, you have to sign as grantor to relinquish control. And then we get into some of the minutes, and then in the particulars from there for each person and what in particular they're looking for.
And then Joan asks, can trustees, protector, and beneficiaries be added later if the trust is set up using a nominee grantor?
Well, in order for me to write the document, I need the names of the trustees and at least one beneficiary.
Right. So other things can be added later?
In the course of time, there'll be many changes to names, and we don't show them so we can protect the innocent. Yeah, it's all going to change because the whole intent is to have your estate go from generation to generation, and all those names will change. The beneficiaries will change. Some will leave, some will not. Trustees will come and go, and you have the ability in the initial stages to add or subtract trustees and beneficiaries during your lifetime.
But to get the trust initially set up and activated, it would need at least a minimum of
3.
The grantor, the beneficiary, and 2 trustees, right?
At least, or at least a trustee and a successor trustee.
Right.
Yeah.
Right. All right. Truby asks, my question is, how would a beneficiary know what a trustee is doing if they are not actually looking over the said trustee's shoulders as far as malfeasance is concerned?
They don't have any business looking over the shoulder of the trustees. They are told in an initial setting that they're going to be a beneficiary and the value is going to be so much. And as long as they get that value on a regular basis, um, they really don't have anything to say. Now they can ask the trustees for a financial statement. Say every year um, the trust will want to have a yearly financial statement, and they can have access to that. And once they have it, they'll see where the expenses were, what income came in, how the asset base has been multiplied, whether it's been given out to the beneficiaries or whether it's been kept by the trust. This is why we call it a discretionary trust, because the trustees have the discretion to either pay out or hold on to increase in assets. So there's income and there's principal, and that can the trustees have the right to pay income, and they also have the right to pay out of the principal. Let's say there's not enough income in a particular year, they can go into the principal asset of the trust and start to pay out, say, let's say it's stocks or bonds, and they can trade some of the stocks to be able to pay the beneficiaries for that year.
So the beneficiary couldn't charge malfeasance unless he just doesn't get paid what he's owed, right?
He would really have to have a good reason to
Yeah,
go after the trustee for a malfeasance. Yeah.
yeah. We have a hand up.
It has never happened in all the 50 plus years, 40 plus years.
We know of no instances where that's happened. Yeah.
I don't. Nobody's come on my door, like I said.
We have a hand up from Kristen. Kristen, you are unmuted. You're on the air.
Thank you. Hi, Rand, Kristen. So we have a private trust, and it's something that we got through a group that's no longer in operation, unfortunately, and we don't have access to the gentleman that knew his stuff and was guiding us through the experience. And so we have this trust with an EIN number, but how do you actually operate in business and in commerce with a private trust and this EIN number, as far as moving assets through stocks, dividends, all of that, while what's the tax liability, and how do you operate in business, in commerce for the beneficiary?
I don't know how your trust operates, but basically, and what I do, if I have a retail business or a storefront, then I would have it as an LLC. This is just for the story, and you have it as a trust. So the trust would be operating, and it would have a year-end statement, financial statement. And then you're going to, or if you work with me, we'll figure out a way to have the beneficiary of that trust also include maybe the trust that we set up in the future if you do that. Or if you have certain beneficiaries now, we'd figure out a way to make that happen. And I would have to see the trust document and see how it's set out. And but we could probably work through an email and at least get the gist of what's happening. But you would just operate it like any storefront. You would have ABC Trust doing this particular thing, and if anybody is paying you and they want a 1099 or whatever, then you would give them the EIN number for the pre-existing trust that you have right now. Does that help?
Kristen?
Can you hear me?
Yeah, now.
Thanks. Yeah, I was muted. Thanks for muting me. Yeah, so with that, if you're dealing with that, then what's the tax liability on money you're bringing through that EIN number? Like,
I
are
don't
you
know.
actually filing taxes?
I'd have to look at it, but if, let's say you have this pre-existing trust now, and it has it has a current business, then what you do is that trust will pay this new trust that we may or may not create with you, and then that first trust really has no tax liability because it's allowed by law. Trust is allowed by law to give 100% of its potential profit to the beneficiaries, and therefore has no liability. And then if you work with one that we have, then there's no need to file for that either. Now that depends on how we set it up and what we do to set that up correctly. I guess we lost her. We lost everybody.
Okay, well, we'll go to the next one. Thank you, Kristen. Crypto Art, you are unmuted and you are on the air.
Hey, Thompson. Hey, Randall. How are you guys?
All right.
So if I have 3 different people that I do work for and they're willing to pay to the order of my trust, the trust, because of the way it was set up with you guys, isn't required to file taxes, right? Or what are
Correct.
so am I doing that correctly then, wherein they're filing with the IRS themselves, I guess, that they paid this particular trust with this particular EIN number, this amount of money, and it goes into the trust bank account. I'm, as a person, not responsible because I haven't been paid, right?
Well, you haven't been paid by them, the vendor, but you'll be paid out of the trust, and you may be responsible on your personal part for what you receive from the trust. And
so I guess I have to figure out whether or how to, I mean, if at all, to document that I'm being paid or that I'm having a withdrawal or something like that?
No, it's not up to you necessarily. It would be up to the vendor, and he'll file when and if he does his tax situation, he'll file and you'll receive a K-1 or a 1099 that he wants to get rid of it off his book, so he'll file one of those 2 forms so that he's not responsible for you, and it's up to you and or the trust to deal with it from there. And we can help you all around that whole process when it comes into your pocket or the trust pocket.
Yeah, it goes straight into the trust bank, and every once in a while, like, I'll withdraw some money with the debit card as the manager of the trust.
That's fine. And I want you to be really clear, and everybody else is listening, that when you withdraw, that if you're using the card, that use that card for trust business, trust expenses. If you are taking it for your own personal use, I suggest that you cut a check or you put it down as putting it into your personal account, and then the trust would have on its ledger that it didn't pay personal items for you, but it paid you personally, and you exchange it to use yourself, but it went to you, and so the trust can give you a 1099, and it's relieved of any kind of tax liability itself. Yeah, I mean, it's kind of like
Say
Say again?
I'm sorry. Okay, we were just having a little delay. I said I won't take any more of your time, but maybe I'll just email you some questions.
Yeah, please do. You can draw it
Thank you
out.
so much, Fred.
You're welcome.
Alrighty.
Thank you. All right. Hans says, when I applied for the TIN with the IRS, it said that I have to file by April 15th. Do I just ignore this, or what do I have to do?
I ignore it every year.
In other words, you're not advising him what to do. You're just saying what you've done, huh?
That's all I can say. It's your choice, but there's no need to file if you don't want to.
Yeah.
They always do that. When you apply for an EIN number, they got to tag somebody. So they always say you're required to file. Well, okay, show me the proof. Where does it say? Under law, and what law is it? It says I'm required to do this for you. It's really easy. It's so basic, and they just intimidate everybody, and so that's how it goes. And we're gonna, Tanzan and I, our mission is to unintimidate you, so that you can just say, "Wait a minute, I'm this, I'm this, I'm this, I'm not that." And if you think I'm that, then please show me that I am that, because otherwise, I'm this.
And we have had rarely ever any inquiries from the IRS like that. Very
No.
rare, very rare. And all it has taken is just a statement in response, and it's finished. So there's been no battles about it. So everyone needs to know that when you apply for the EIN, it will say in the letter that comes with it, you are required to file Form 1041.
Right.
But they're assuming that it's a statutory trust. They just assume that because they don't want to recognize these trusts.
Well, it's not that. They just assume anybody is a taxpayer. That's
Right.
their job. And if you're not a taxpayer, then you make them say that you are and how you are. It's pretty simple, but it's a tough stance to hold if you really don't understand and you haven't been doing this for a number of years. And it's really enlightening when you get to that place where, hey, I'm sorry, show me. I'm from Missouri.
That's right. And the relevant wisdom is the only rights you have are the rights you know you have.
Exactly.
If you know you have the right to ignore that, then you can exercise that right.
Right. And don't be afraid to email Tanzan or myself.
All right. We have a hand up from Marek of the House of Wolves. Now, that's an interesting name. Okay, Marek, we're going to unmute you, and you're on the air.
Hey, guys. It's actually Carrie. Mark is my husband.
Oh, okay.
How are you both?
Great.
We're alive and well here.
Good. And he did this on he turned it on his computer, so I'm a little malfunctioning on it, which is a PC. But I also wrote my question to everyone. But I had called you the other day, Randall, and I thought I'd just ask you right now live. Maybe it'll help other people. When I set my trust up, I set myself up as as a trustee. I have another person who is a trustee who's unrelated.
Mm-hmm.
And I actually set Marek, who's now my husband, but wasn't then, up as the beneficiary because we were just working together on things.
Okay.
And we were married in Mexico, not in the U.S. So I think to be considered married in the U.S., we have to do it there, but I don't know if we will. But anyway.
Ray, just hold on to that for a minute. I'm just going to say that you're in a close relationship with your partner. And so I would have a non-related, a little bit, a step aside that can also be part of that process so that somebody won't come back on you and say, well, I don't care whether you got married in Mexico and you're not married in the U.S. You basically are a partnership. And so I want you to be delicate around that and consider what the ramification might be. And we can talk about that again personally.
Okay. So can I become a beneficiary? I already have one person who's unrelated who is a trustee, but should we get another trustee, and could I be a beneficiary, or?
A second beneficiary might be good, or at least a successor beneficiary. I mean, a successor trustee.
Yeah.
And you could easily be also a beneficiary.
Okay.
And you can take a salary or a fees as a trustee also.
Okay. Great. Cool. I'll ask you more in detail in person soon.
Sure.
But good. I just want you guys to know I appreciate so much the education you're doing on this. I'm rebuilding my website right now, and I'm hoping to share what you're doing with more people. It's awesome. Thank you, thank you, thank you.
You're most welcome.
Thank you, and thank you for helping us get this Zoom series started a couple years ago.
I know, huh? I'm so glad you're doing it. It's really good. It touches my soul and my heart, and I feel like it's so important right now. So thank you for the service.
Back at you.
Okay.
Blessings.
Thanks.
Jeremy asks, so can the trust be in the name and unique EIN of the company?
No, trust needs to have its own EIN number. I think that's the direction you were looking for, but the company, does the company already exist and have its own EIN number?
That's what it sounds like.
Then you would need to have a new EIN number for the trust, because that's a separate entity, and I would want you to keep it separate from the company. And then the company can be or the trust can be a shareholder of the company, and we can go about it that way.
And as far as the name, I guess that's up to him, huh?
Well, you'd want to I would suggest a name separate from the company.
Yeah.
Anyone else?
So then we have a whole bunch of questions in chat here. Let's see. Here's a real basic question from someone named Office. How can you use the trust to eliminate or reduce taxes?
Easy. You have, that's numerous directions. So are you creating a storefront with a trust? Is it receiving just your assets that you already own? Is it coming from another place into you? Are you trying to shuffle your employee wage into the trust? That's a whole other question. And so I'd need to have you define, I guess, that basic question.
And then Chuck asks, how much of the 30-page natural trust is given to the bank in order to open an account?
That's a good one. There's 5 parts to the trust, and the first part is called the trust indenture, and you want to make a copy of that once it is signed. You're going to sign the whole trust document, then you're going to make copies, and first thing you do, make a copy of the whole 30 to 40 pages, depending on how we set it up. And you're going to then you're going to take and you're going to make say a couple of copies of the trust indenture, which is the first 13 or 15 pages, and that's stapled together each one. And then you're going to take a copy and make copies of the abstract, and you're going to take that 6 or 8 page abstract, depending on what we put in there, and that's stapled, and those 2 parts are what you'll leave with the bank. Now, it doesn't mean that you don't take the whole trust document to the bank. The bank may want to see the whole document, but you say, Mr. Banker, you can see the whole document, but here are the pieces that I'm willing to leave with you that you can put in the bank records, but you can't have the whole trust document. And thank you very much. And typically they will go with that if they're going to open the trust account at all.
Yeah.
So it depends on the bank. Some banks are really friendly. Some you might have a relationship already with a banker, and even though the bank in general won't, doesn't like what they're looking at, but your relationship with the manager may be such that he'll say, "Okay, we'll do this, and it'll work." It depends. It all depends. I mean, I live here 3,000 miles from anywhere, and fortunately I've had a couple of banker people that have been really assisting me in being able to do it all through either usually if it needs a notary or it needs a witnessing, then it's done by UPS or FedEx or whatever. And it's rare that they will take scans. They want to see hard copy, but it can be done. It can be anywhere. People in Carrie just said she was in Mexico. Somebody was just done in Mexico, and it can all be done there. I have clients that they're on the West Coast and their trustees are on the East Coast, and it's just timing and setting it up. And a lot of it can be done by scan, fortunately. So you get it done. The notary, I have a notary that will take faxes, and I often fax documents from here to the mainland.
Emerval asks, can you give us some example structures that your clients have set up that are the most simple? For example, a model trust set up for somebody who is anticipating the RV and just wants to be prepared prior to the RV transition taking place.
Okay, so the first thing you do when you become a client with us is pay your initial payment, whatever that minimum is, plus more if you want to do more, and you'll have a form. Tanzan or the website has a form, and if you can't always access it, then I have a form that I send to make sure, and we give an abstract out. And the first thing you want to do is get that abstract, read through it, make sure all the names are right, and then you're going to make sure that the most important document on that abstract is the personal property for foreign currency. And then you're going to list the foreign currency that you have. And that can be just the total, like you have so many dings and so many dongs and so many zim. And that is, you don't have to give a detailed spreadsheet on that. You just need the totals. And then at the bottom, you're going to go to a notary. And this is how I've changed it from having to have a notary, because in Europe, my friends in Europe say a notary is $100 here. Can we do a witness? So I now have 2 witness process. So on that page where the notary is also a witness statement, and those 2 non-related witnesses will witness your signature, and that's as valid as a notary. And that's the page that's most important, because that means that you no longer own that foreign currency. It is now in the ownership of the trust. And when the RV happens, the exchange happens, you're going to go as a manager or a trustee for the trust. And so that new script and the new value of the script will be going to the trust and not to you.
Yes, thank you. I don't know if she meant, a model meaning like typical, who is trustee and who is, that varies from case to case. So, uh,
Well, the basic is the grantor, either you or someone else, a nominee grantor, and two trustees, or one trustee and a successor trustee, and then beneficiary, which can be one or a number.
and I generally tell people if they're considering being trustee, it just depends on how familiar and what kind of aptitude they have, for management.
Right. Well, that's really good. Some people, have a problem giving up control, and I coach people on, look, it's giving up control, but having all the benefit is more valuable than trying to hang on to something. So there's that aspect, but the basic model is, it's a 35-page document that where you and your assets are no longer connected in the same pocket, and they're protected from anything that you might do or anything that might happen to you, and yet it can go on and on and on. All the wealthy do that. Now, whether you're wealthy or not, you have a basic paradigm for contractual basis. It's a contract between 3 or 4 people.
Then Mata asks, how does one handle multiple contributors of assets to the trust if they are not the grantor? Example, other trusts or LLCs. Can additional assets be contributed in future years?
Sure. And you just have to recognize who's getting that, and whether it's a gift or it's income to the trust, or if it's, let's say, it's in the case of the foreign currency. I have a couple of clients, and they have 3 or 4 people that want to have their currency go through that particular trust. So we set it up so that each one of those 4 people would be a beneficiary of that particular process. Not necessarily of the whole trust, but at least of the RV, the exchange for foreign currency.
Okay, and Richard asked, does the trust need to have an expiration date?
No, there's no expiration date. It goes for 21 years plus lives in being once you sign the indenture. So if it's signed today, it'd be a minimum of 21 years. And if you have a family, then it would be 21 years beyond them. And it just goes on. And it can be terminated if all the beneficiaries agree. Then it can be terminated at some point, and the assets are given out to each beneficiary. So you can do multiple income sources, whether it's people participating in foreign currency or different forms of income. You might have a couple of businesses that want to participate in your vision. So there's numerous ways, and typically that's I look at that on individual basis, and how, when I talk to you, how you want to see that process happen.
And then, of course, at the end of that period, it can be renewed, yeah?
Yes.
And Jim asked, would a trust that is just for your home as an asset be the same type of trust used for humanitarian purposes?
Sure. Same thing. It's just what the asset base is. The asset is a thing. It's either a house or currency or gold or stocks. Doesn't matter. It holds it, and it can hold multiple assets. When the asset base starts to be significant, then I might say you might want to consider that we create another trust, and we stocks and bonds probably in one, and gold and silver in another, and other thing, or foreign currency in that third. It just depends. Everybody has their vision, and if it's a smaller portfolio, then it can all stay in one base.
And you could also say that it doesn't need to get an EIN if they're only going to put real estate in it, right?
Well, if you're going to put real estate in, you're going to have to record it with the county, and therefore they're going to want to see an EIN number or some
Okay.
number to go with. So yeah, real estate, in order for the trust to absorb that real estate and own it legally, then it has to go on the county books.
Right.
Because the property tax will follow the property. So you want to make sure that you record it so that when you get the tax bill, it's not in your name, it's in the name of the trust. And you want to make sure that the trust does cover the property tax, because they will come and get it no matter who owns it, unless you have clear title to it, which is a whole new seminar.
Yes. Tony asks, is the payout to the beneficiary taxable?
It typically would go, the tax liability would be on the beneficiary.
Right. And he says, how do we avoid taxes to the beneficiary?
Well, that's another seminar and another particularly gifted gentleman that we work with to do that.
In other words, that's not the scope of this.
No, not for the trust and not for this particular day-to-day, but we have the people in place for protecting your personal being around the IRS, Mr. IRS man, and the same with the trust property and assets, and it's quite extensive. So,
Well, one thing you could say is have the beneficiary get a natural law trust.
Absolutely. Well, that's the whole idea. But there's still, it's got to end somewhere. So in other words, if you got a natural law trust and it pays the beneficiary and it pays through another trust, then the other trust has got to do the same thing. So you're just running this circle, and it's going to lead ultimately to somebody is going to have to stand up and say, I'm sorry, we're not liable for this, but I would end it sooner than later. So if you have a trust and you have an asset in it and you receive benefit from the trust, then you figure out how to not be liable personally. And that's, like I said, a different gentleman and a different equation.
You mean you don't want it to be like the Social Security Administration, which is a pyramid?
Exactly.
Aubrey,
we're not running any pyramids here.
No,
we've been too involved with other pyramids, so
we just run geodesic domes.
Right, exactly.
Abra says it would be great to go over creating minutes and other trust documents in the actual running of the trust. So here, Randall, is a request for future topics.
Minutes and other trusts. What would that
Other
look
trust
like?
documents.
There's only one trust document. The minutes are the flexibility part. So in other words, I'm going to give you a basic document, and that first 30 pages is going to stay static, basically. However, from that point on, you and the other trustees that's the fluid part of the trust, and that will change every time you will make a decision, every time you take any action. That's going to be recorded, just like in any business. You make a record of expenses and expenditures and income, and the same with the trust. The basic document is sealed and signed, and then the fluidity comes in you and the trustees creating minutes from there.
Yeah. And in future webinars, perhaps you can go in more depth on that.
We could do a whole thing on the minutes.
You could show examples of minutes, and things like that.
Oh, yeah, for sure. I mean, yes. It's basically just writing up another contract. It's one page at a time, one sentence at a time. Some minutes are 2 sentences or paragraph long. Some might be, we're going to entertain an enterprise with these people and we want to create this such and such, and that's it. It's your flexibility, your creativity. It's like sitting down and writing a book. That's all the minutes are. It's a record of your creativity. And yeah, we could do that. You're creative.
And the templates for minutes come with the trust.
Well, that's a basic template. And that's the first minute. And in getting a natural trust, you have made a basic premise. And you've looked at that and you said, it's basically just the minute that creates the whole document and how it's going to work. And then the actions that you take as trustee and or the grantor will go from there. And then that becomes like a new chapter. So yeah, we can do with that. I can give examples, but we'll do that. Do something like that.
Okay, Sanu asks, can you purchase precious metals like gold from the trust account?
Absolutely. That's an investment.
Mm-hmm.
The trust is investing in gold, silver, or whatever. It has an account. I have all those different assets, whatever you want to invest in, or whatever the trust wants to invest in. I just saw a flash on trustee training. We do that, and we have a beautiful woman. One of our crew is offering trustee seminars and expanding on the issues that I talk upon, and I'm mentoring her, and she's very adept and she's very excited, and she's a lot younger than I am, so she's going to last a lot longer. So we're going to try to put that in order so that she's ready to go. And that's why we are offering her as a nominee grantor service and for being a co-trustee, either being a trustee service by yourself, which you can do, and because when you have a trustee service, then you just need that one trustee, because she's already had, her service has already got the list in order for any successor process that needs to happen. So we're picking up that ball and we're putting a really good cover on it so we can hit it out of the park.
Yeah, so what Randall is referring to, everyone, is Dominique's study group webinars done on Zoom also once a month. The last one was April 10th. The next one will be May 8th. And those are for trust clients only, those who have purchased a natural law trust, whereas these webinars with Randall are open to anyone. James asks, why does a natural common law trust become involved in statutory law by issuing 1099s?
And by issuing, it doesn't have to issue a 1099 unless it wants to. But it can, and that takes the sting. In other words, I don't understand why the trust would issue a 1099 to begin with, but it could do that or it could not. It doesn't have to do that. 1099s are always an option on the vendor. Oftentimes, because they're involved heavily with the statutory process, that's the way they get rid of their tax liability.
All right, Mata asks, if the trust is a member of an LLC, can the assets of the LLC later be transferred into the trust?
Yes, but I wouldn't bother with that. I would have the LLC contain contain that asset, and that the trust is a majority member of that LLC. So in a sense, that trust really owns that asset that's in the LLC, but it could be transferred from the LLC into the trust. But I would, if it's already there and it's established, then I would have a tendency to say you might want to leave it there. Same thing happens with a business. If you have an established storefront business, then leave that in that mechanism that you're using, an LLC or a corp or even an S corp, and have the trust be a member or a participant or a shareholder in that project.
All right. Here's a good question from Richard. Can the trust give units of beneficial interest to non-grantor contributors in exchange for assets placed into the trust?
Yes. And that would be, again, go back into the trustees say, yeah, we'll do this. And then they, depending on the value of the asset, they receive it. It's assigned to the trust. And in exchange for that, they prioritize the percentage base of everything. Let's say the asset base for the trust right now is $100,000, and the person putting in the asset, that asset is valued at $20,000. So we want to give that person 20% of beneficial interest. So everybody else will go down accordingly, and it would be pro rata. So it might not necessarily be 20%, but it would be of equitable value that person would want to put the asset into the trust. And everybody else would be happy with it too, because it would add to the asset base of the trust, and everybody would benefit more from that.
And when we say we're giving 100 units, does that mean it's a percentage, or is it just a number of units that can be unlimited?
No, the units are based on 100. That's all there is. And so the beneficial interest is based on a percentage, and that will in turn give you certain number of units. And that all is probably going to be adjusted over time. And if somebody has a certificate for 20 units and they're going to get more or they're going to get less, then they would return the certificate to the trustees. The trustees would write out a new certificate, and then it would, even though, like, say they got a certificate for only 10 units instead of 20, but that 10 unit certificate maybe have more value than the prior 20 units. So it's all based on a percentage of the asset value of what anybody puts into the trust.
Excellent. He also says, same question as the last extended, or for contributions of intellectual property or labor in contrast to the physical assets. Meaning, his question is basically, can the trust give units of beneficial interest in exchange for those things?
Sure.
Right.
And it would all be decided upon by trustees, and the person putting in that intellectual basis would have to decide whether that's a satisfying return.
We have a question here that was sent to me privately, but I think would be of interest to everyone. And so without saying your name, I'll just say that this person asked, I have only a trust abstract and have not been able to afford the full payment. At the exchange, it is being said that we should use the skeleton trust provided by the bank until a trust is fully set up within 90 days. Can I use the abstract to go ahead and exchange into the trust even though it is not complete?
Absolutely. That's why we do the abstract. Donson and I talked about this a couple of years ago, and we said, how can we offer the ability? And the first time we started to do it, we just did 2 pages, and you assigned the currency, foreign currency, to this nebulous entity out there, and we taught you how to get an EIN number, and then we expanded it to an 8-page abstract, and would not trade it for anything, any skeleton trust that the bank's going to offer, because you have that will suck you right into their control. And if they say there's 90 days, then you have 90 days to complete the trust with us anyway. So you might as well take advantage of the natural law trust, and we can fulfill that order, in 72 hours or so. We just fill it out, and it's the basic, the basic abstract is pretty complete within itself. It conceptualizes the whole trust, the intent, all the people involved, what it's going to do, etc. So you have a pretty full document, and the only reason you're going to want more is the bank obviously wants a little more paperwork, and so we give them more paperwork.
Yep, you don't want any skeletons in your closet.
Yeah, good. That's very good.
Richard asked, do you offer trustee training as part of your original trust package or for a separate fee? Well, Richard, that's what the study group is about that we announced earlier.
Yeah, with Dominique.
Right. She's going to be covering trustee training. That was the purpose of setting up that series, and there is no fee. So you just have to be a natural law trust client.
And she's coming along very well. And
she's doing extremely well.
She's really fun to work with. And it's good to have somebody else doing that, and so I can focus on writing the documents and making sure that they're well handled. And then I work with each of you individually for any questions you have, and so it's not a problem. And I see Kristen's got her hand raised. Has she got a question?
All right, Kristen, you are unmuted. Well, if let me see if my mouse will work here. I clicked on unmute, but it doesn't seem to be doing anything.
You don't tell me you don't have a dead mouse over there.
Oh man! All right. I'm clicking on unmute and nothing's happening.
Okay.
But I see
Kristen will contact me, I'm sure. It's not a problem.
I see a question from Kristen in the chat. How much does Randall ask for doing a trust and consultation? How do we contact Randall? And Kristen, the answer is go to your affiliate, whoever referred you to Brilliance in Commerce, and ask them for their link. If you found us from Google or don't have an affiliate, then just go to the address at the bottom of the screen and place your order there. Then Randall will be happy to serve you and help you.
You bet. You betcha.
David says, putting a U.S. futures trading corporate into a collato, common law trust organization, is it best to open the corporate account, trading account, in a sole proprietorship?
Hey, Mom, slow down.
Hey, Mom, slow down. Looks like we got a chat line. It's open. Okay, you'll have to run that, but you're talking about a futures trading account, and I would suggest that rather than go through the process of opening the account and then having to change all the paperwork once you create the trust, that you get busy and create the trust and then go and open up the futures account or whatever account you're going to be under the name of the trust.
Absolutely. Yeah, just open the futures trading account in the name of the trust.
Yep. And for that, they'll want an EIN number. So we have to You have to do that, and if you start the process of a natural law trust, then we give you instructions on how to go online and get an EIN number in about 15 or 20 minutes.
Well, Susan says, is there a playback for the last trustee study group? That, you mean, Dominique's, that is just now going to be placed in the back office of every trust client under login. So soon, so the next day or two, we expect that to be posted along with the spreadsheet that goes with it. So Susan, I hope that answers your question. Replays for the study group are not going to be made public. They're only going to be in the account of trust customers. But the playbacks for these webinars with Randall are posted here, as you can see on the screen, brilliance-videos.com. We're getting near the end of the questions, but let's see. James says, earlier you said that if a beneficiary uses debit card to withdraw funds from the trust would issue the beneficiary a 1099.
Well, I'm suggesting that you don't use the debit card to buy things that are for your personal use. I'm suggesting that you take that debit card and you pay your personal checking account with it, if that's what you want to do, or you write yourself a check from the trust for you personally. And then the trust can file or give you a 1099, or it can choose not to, depending on how it wants to play the game. That's entirely up to you and the trustees and your preference on where you want to go as far as the whole process around the government. And that's, I don't want to go there.
We have a good question from Tony. What is the best book to read regarding common law trusts?
One is, what is it? Let's I'm crawling away. It's the one we used, the little paperback book from California.
Passing the Buck?
Passing the Buck, sorry. I've been on the green screen too long. Yeah, Passing the Buck. And then there's another one. We have Tanzania of the bibliography posted somewhere on your...
No, but I was wondering if you're putting it in the manual now.
It may be, but I will
make sure.
I'll put it in manual. And you can write to me, or everybody can write to you, and we'll figure out whether it's a button that we can put on the on your website, or I'll have it. Well, if they're gonna go on your website, then they're gonna sign up. Excuse me, and they're gonna start, and the first thing I do is send them a form and a manual so that they have, and I can also send them the bibliography. But there's really, the first thing to do is, rather than go and looking at the bibliography, the first thing to do is make sure you understand the manual, and then you understand the trust document. And then I will be more than happy to help you go into the bibliography, what book is best for you, how much really do you want to learn. The more you learn, obviously, the better. And but I'm doing all of that right now with Dominique, and she would love to, mentor anybody that wants to have her trustee service.
And also, these books are being reviewed by Dominique in her study group series. She's going to be going through them.
That's great. And that's where you learn. And some are very complex, and it's based on statutory law, so it gets a little confusing. And that's why I'm not I'd rather have Dominique, the information come from us, than for you to go and buy all these books and then get into this place, because most of them are just enhancements of the basic paradigm of a common law or a natural law trust. And I'd rather have you clear on a couple issues and ask questions than to try to learn everything that's taken us years to really make simple.
Therein lies genius, my friend, as you know, is making the complex simple.
Yep, you're right, Tanzan.
So,
okay, let's wrap it up.
Ladies and gentlemen, brothers and sisters, thank you very, very much. This was fun. We enjoyed it. That looks like the end of the questions for the moment. And we've had some very nice comments, Randall, coming back.
Great. And if anybody really needs, any of the clients need to talk with me, then send me an email. You probably, if you're a client, you have my email, you have my number. And if you're not a client yet, then get quick about it, and then we can talk personally and go from there.
And Randall, good health and wellness to you and your consort on behalf of all of us.
Thank you very much. It's been a tough week or a long week, so thank you.
Yeah. All
okay.
Right.
Aloha, everybody. Have a wonderful rest of the evening, and we'll go from there. See you next month.
Merci beaucoup and mahalo.
Aloha.
Aloha. Aloha.